Hi there, I'm Clifford Bates, and welcome once again to Reading Carl Schmitt. Um, uh, we're focusing on reading Schmitt's Legality and Legitimacy. Today we're starting part two of it, which part two is divided in three chapters, chapter 3, 4, and 5. Why am I doing this right away, not going into 3 immediately, is because we have to understand the threefold characteristics, the three extraordinary lawgivers of the Constitution. And these lawgivers are, again, legislators, the structure who makes those who give the law. And he divides it into three principles. He says the extraordinary lawgiver in three parts. That is, each chapter deals with a part. The reason of matter, the material, the material or the matter, of the subject of this, right? The reason of the matter, the reason of supremacy, chapter 4, and the reason of necessity. What's going on here? The necessity of the thing, and that shapes the whole thrust of what's going on in this thing of these three things. So let's turn to chapter 3. Let's go right to it. So let's go to our little chapter comments that this. And it goes to the three things, and we'll go right here to chapter 3. The extraordinary lawgiver, the rationale materia, the second principal part of the Weimar Constitution as the second constitution. So this idea is the second constitution. In the parliamentary legislative state, law is the present decision of the transitory parliamentary majority. So in the parliamentary state, law is the present decision of the transitory parliamentary majority. In direct democracy, it is the transitory will of the present people's majority. Along the consequences of the democratic majority principle is, first, the transitory character of majorities, and second, the simple, thus 51% majority. But there are indeed exceptions to the principle of the simple majority in most democratic constitutions. For certain cases, a smaller majority is required, while in others, a higher quorum is demanded. It is important to determine whether such deviations from the principle of simple majority are related to procedural questions, are related simply to the procedural question. For example, whether a qualified majority of 2/3 is necessary to exclude the public under Article 29 of the Weimar Constitution, whether for the convening of the Reichstag, according to Article 24, only 1/3 vote is required, or whether the deviation of a certain substantive decision as well as a principle of substantive law is introduced. So there were three things. The 31% vote is, or whether the 1/3 vote was with that, or whether the deviation for a certain substantive decision as when a principle of substantive law is introduced, right? Also, the question of constitutional amendment, Article 676, is essentially different depending on whether under Constitution is understood organizational and procedural rules or also principles of substantive law. Only cases involving a substantive law norm exhibits an obvious and fundamentally deviation from and change in the principle of the simple majority. So only cases involving some substantive law norm exhibits an obvious and fundamental deviation from this, right? In these cases, however, it is constantly a matter of making the process of decision more difficult, not easier, by stipulating the passage requires more than 51%. In the second principal part of the Weimar Constitution, these substantive law qualifications, when viewed in terms of constitutional history, are introduced in unparalleled scope through empty anchorings, guarantees, invariable declarations, securities, and other substantive law entrenchments. The second principal part of the Weimar Constitution bears the inexact, actual, misleading title, the fundamental rights and duties of the German people. In truth, set against the first principal part, organizing the parliamentary legislative state, It is second, heterogeneous constitution. It is the principal part organizing the parliamentary legislative state. It is a secondary heterogeneous constitution. So therefore, the first point is a homogeneous constitution. These rights create a heterogeneous constitution. The deviation from the principle of the simple majority takes the form of the requirement of that statutes with definite substantive law content need to qualify two-thirds majority under Article 76. If, for the sake of clarity, we consider here only the Reichstag as the ordinary legislature, and if we leave aside the Reichstag's right of inquiry, then the protection that is essential, that of instead of 51%, now 66.67%, must be consistent to the passage of the statute. Mathematical difference extends to the 15.67%, but though this difference of 15.67%, which in arithmetic terms is naturally only quantitative, one introduces a consequential qualitative change, even a transformation in the legal parliamentary legislative state. For now, the question arises: is the actuality of ratio of this addition of the further 15.67%? What is the reason? What is the actual? What is the actuality of the ratio? What is the actuality, the ratio of this addition, this 30%? The reason, the ratio, reason of this. What is what is the quality and dignity of the additional quantum based, which is in contrast to the simple lawgiver, capable of constituting the higher type of lawgiver and more robust legality. In other words, what is this? What justifies it from being this? That the simple majority is decisive for the question at hand justifies it as a method of will determining and does not violate the assumption of the homogeneity of democratic people. Obviously, it is different with the requirement of the additional 15.67%. One might perhaps object that only in practical technical problems is only a practical technical problem is involved here. In particular, the interest in making passage of a statute more difficult. 66 or 67% would not be easy. Would not be as easy to achieve as 51. Solely at issue then would be the interest in restraining and perhaps the thought of corresponding probably of better. In other words, restraining and perhaps the thought of a correspondingly probably of better, more just decisions. Right? This is how you make it. When considered more closely, this explanation, which is in itself thoroughly plausible, says nothing more than that 66 is quantitatively more than 51, which is without doubt true, but which does not address the substantive constitutional problem. In other words, one is higher than the other, but how this is, in other words, how is this the constitutional problem is? Well, who makes the decision? Why is 67 necessary? And it's just okay. The question from the constitutional theory is directed at something else, namely at the central value of legislative state, the lawmaker, the concept of statute, and of its legality. So therefore, the constitutional question is aimed at the question value of the legislative state, the central value of the lawmaker. If a new type of lawmaker established, although through the additional 15%, then the point about merely making the process of decision more difficult is in no regard conclusive. When one ignores any special quality of the additional 15% and the democratic presupposition of heterogeneity is out of account. So in other words, something happened. What is so important that 15% is so important? it seems to maybe deny that there's democratic homogeneity and therefore denies the principle of majority. If the simple and qualified majority is one and the same identical lawgiver, then it is only a matter of an internal modification, so to speak, in the order of business. So there is not a contradiction between lower and higher norms. So it's a question of order of business, not in principle. Considered only as a qualitative obstacle, threshold requirements can be at most negatively a practical means of limitation. Right? I'm trying to limit, but they contain neither a general positive principle of justice or reason, nor a special constitutional perspective. So therefore, they're just the technique to kind of restrain or do this. Right? It doesn't offer a positive argument. He's saying it doesn't offer neither a general positive principle or a reason, nor a special constitutional perspective. They are not even given. They are not even something especially democratic. Right? He's saying. Right. In general, it would be a particular type of justice to declare a majority all the better and more just, the more overwhelming it is, and to maintain abstractly that 98 people abusing two persons is by far not so unjust as 51 people mistreating 49, right? Okay. In other words, that this is, in other words, okay, this is an interesting point, he's saying. Moreover, maintain that abstractly that 98 people abusing two people is by far not so unjust as 51 mistreat 49. At this point, pure mathematics becomes simply inhumanity. In other words, that they're saying that it's saying that that 98 on being unjust to two is more just than 51 doing 49. Okay, this is simple. This mathematics becomes simple in humanity. Yet it would be no way especially democratic to say that the passage of a statute that is qualified and its significance in terms of justice is judged as such by the numerical size of its majority, and that in view of the proceedings and without any regard for content, a decision achieved with 67% of the vote is the norm that is 16 degrees higher in value than the one finding only in 15% majority. So therefore, this one is more just than this one. Okay, they were stronger in that sense. View. In the case of interest here, the distinction between simple and higher statute rests not only on the principle of the quorum, but rather the will of the Constitution, right? So this higher statute, this simple and higher statutes, rest on the principle of the quorum, rest not on the principle of the quorum, but rather the will of the Constitution, right? Once again, however, according to the general democratic principle, these can come about with a simple majority. The requirement of an added additional number of votes beyond that of a simple majority cannot be justified. So, right? Therefore, by democratic principles. Therefore, by democratic principles, and still less by the logic of justice, humanity, and reason, but only by practical technical considerations of the present situation. So, therefore, this is the idea that this is aimed at that only the concern of prudence and the present situation is this justified. It's neither a principle of justice nor a principle of democracy that require these supermajorities. Every democracy, even the parliamentary variety, fundamentally rests on a presupposed homogeneity that is thorough and indivisible. As noted, if democracy is to flourish, every vote only has a sense of bringing about agreement. as a mode of confirming the unanimity that must always be present at the lower level, instead of an agreement in the form of a majority voting down the dominating and violating of a minority. Since democracy generally provides no legitimate basis for a lasting and organized division of the people into majority and minority, there is also an interest that merits and needs enduring protection from the majority. In other words, there is also not an interest that merit. So since there is no consideration of a democratic principle does not establish the conditions of a permanent minority and majority, and because of that, it does not. Basically, what he's doing here is giving us the principle of the Weimar Code, which is a repudiation of what our Federalists would have argued. This is the problem with modern democratic thinking. This idea of this legislative state and the equal chances of this view of parliamentary structures that came out and that formed Weimar, of this legal positivism that shapes it, that repudiated the importance of prudence that the framers and the American Constitution insisted, and the Federalist Papers even insists on these things. At Philadelphia, the prudence of the statesmen at the Constitution at Philadelphia were understanding that they just simply did not impose a democratic government. They created a process that tried to aim at justice, but also that understood the limits of justice and the limits of even popular rule in that sense. That their prudence moderated their justice and their principles. They didn't simply just follow principles in a sense. And I think this is the situation that he's talking about here, right? As soon as the perspective of the desirability of and the need of such protections of substantively definite interests and rights intrudes violently and decisively into the Constitution, the democratic principle is not only modified, but an essential different type of Constitution is established. So once you bring in that there is definite interests, that is no longer a homogeneity, but there's different groups who have different interests and rights, this creates a wholly new Constitution, right? That is not modified, it creates a different type of Constitution. In this way, more specifically, either a undemocratic or even anti-democratic mistrust of the majority is being expressed, or certain protected objects, persons or groups of persons, are taken out of democracy, exempted from the bonds of the legal system, and in this way privileged as more or less exclusive, a special community vis-a-vis the majority. Thought through consistently to the conclusion, recognizing the desirability of the need for protecting of a definite interest or group threatened by the majority, leads to their complete shielding from the transitory functionalism of parliamentary and democratic voting methods. Logical consistency requires exemption within into the parts, right? Exemption into the parties, right? Or recognition of the right to exodus or succession. This is certainly not the intention of the second part of the Weimar Constitution. It is only a fragment of another type of constitution, which opposes the empty value neutrality of the democratic parliamentary state constitution. So, in other words, it's a fragment of another type of constitution, the older one, or maybe of the four types. Remember, of another type of what is that? I forget the first type, whatever. Another constitution other words, it's a fragment of another constitution which opposes the empty value neutrality of the democratic parliamentary legislative constitution. Okay? So that it was really an empty, this opposes, the second part opposes the logic of the first part, he's saying. It's a fragment. It's not desired to do anything substantive. If the object of protection is guaranteeing security from the majority, because of its special inner value, perhaps actually due to its uh, 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 s- se- seca- sen- okay. Uh, yes. Sanctity. Jeez. I've been away from America too long and not English. I'm losing my English. God help me. Sanctity. Then the insurance therefore extended that the additional 16% must be added to the 51% majority obviously constitutes a half measure and only emergency assistance. For in terms of its character, the additional 16% is not is not qualified to determine the object of protection itself. It does not have any properties that distinguishes it from the other 51%. They also do not stand in a special relation, whether objective or personal, to the protected object, which would justify requiring their consent to the interference with the object and to the violations of the secured status. For example, it is not as if the elimination of a specially guaranteed interest of religious societies came uh, 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 society, some representation is accorded them, and this consent must be given, or as if the acquired rights of civil servants declared inviolable in Article 129 cannot be impinged, or on against or unequivocal will of the civil service agent or all members of parliament who are civil servants, right? So therefore, this is like, in other words, that for example, if the elimination of of a specifically guaranteed interest of religious societies, some representative temptation is recorded them, and their consent must be given, or on the account, or as if the required rights of civil service declared in this cannot be impinged or on against the unanimous will of the civil service agents or members of the parliament who are civil servants. Rather, it remains a purely mathematical qualitative calculation. In other words, they don't give it. In other words, they don't give certain things. They say it should not be divided, and it needs 51%. It doesn't give a specific body certain say and control of this, like that religious groups. Therefore, they have certain representation, and that group must have that, or some rule against the civil service that the civil service get to say yes or no, right? Um, Rather, it remains a purely mathematical qualitative calculation. That means nothing other than that. And in the same manner, it is the simple arithmetic majority. Unconditional homogeneity is also assumed in this qualified majority, because otherwise addition would not at all be possible according to the still valid principle of primitive arithmetic, because they must be the same thing. Under this presupposition of homogeneity, another vote calculation besides that of the simple majority cannot be justified, at least not in reference to the objectively defined interest in groups. On the one hand, if the assumption of thoroughly homogeneity is given up, if it is acknowledged that the mass of citizens no longer thinks as a unity, but rather in pluralist fashions, divided into a plurality of heterogeneous organized configurations, then it must also be acknowledged that in regard to such homogeneous power groupings, every majority principle loses its meaning. So therefore, there's no possibility. In other words, it's not it's a plurality of systems, and then simple majorities really don't have the same meaning in this model than if it was the argument of a simple majority in terms of the homogeneous thing, right? Um, um, One can only add together sums that are quite similar. In other words, these must be the same thing. The thing in question might be, therefore there is some, because they all represent the same thing. What he's doing is he's taking the principle of mathematics and in terms of mathematical numbers, right? If I just all of a sudden had put two different types of number systems there and added them, well, it's can't get a total. It's two different things. It doesn't, it wouldn't work in this sense. This is why you have to, I say uh, 6 plus 6 plus b. Well, 6 plus 6, the answer could not be, there's no answer unless you do a calculation of something. We say b equals that, right? But we don't know what b equals. There's no way to give an answer to this. There's no question plus b. So whatever b means, that in that sense, you can add these things together, and that plus b is our answer, because that's all we can say at that point, right? That's the whole point here in that sense. Therefore, if they're too different, if they're so different, then they can't be a sum, and the percentage of the sum is not a possible variation. It can't be that, right? Um, uh, Either a single power configures, either a single power configuration has the necessary majority, whether simple or qualified, at its disposal, right? Then everything it does is without question legal, and there is no more protection of all opposing. There's no more protection for all opposing parties. In this case, the additional 15 or 16% means no new justification, because the group of persons constituting this 15 or 16% is comparable in an essential sense to the 51% of the simple majority. But on the contrary, would still it would justly justify a still stronger need for protection. Faced with a simple two-thirds majority, the mistrust of a simple majority must yet must increase yet further, because the dangerous stronger majority is obviously much more of a threat than the dangerous simple majority. Right. So therefore, from the minority point of view, in other words, in other words, that contrary would still more protection, right, not less, because this is a bigger threat. The much thing higher group is a greater threat than the 51% simple majority. Faced with a simple two-thirds majority, the mistrust of the simple majority must increase further, because the dangerous and stronger majority is obviously much more of a threat than the dangerous simple majority. Or the necessary majority first comes into being through a compromise, although heterogeneous parties among heterogeneous party constellation. A statute, then, is the momentary compromise of a heterogeneous power grouping. Then every type of thoroughgoing vote count is also impermissible, and introductions of a qualified voting majority in place of simple majority only means that the additional 15 or 16% is heterogeneous and retains in a completely disconnected way a key provision permitting them to demand unrelated countermeasures. For example, in regards to a conservative Christian group on the one hand and a culturally radical group on the other, and a middle class party could make constant or make it constant or denial of consent to dechristianization and to the secularization of the state, contingent on the elimination of mortgage interest rates. It is well known that similar political business is conceivable and all possible at all times and under all state forms. And some agreements between cabinet councils of absolute monarchs and his mistresses probably also rested on very heterogeneous motives and perspectives. So in other words, it's well known this happens. In other words, this can create this, and this is a critique of pluralism. Pluralism does not. In other words, the argument that pluralism that you can resolve this majority model with pluralism, and no, the same problem will arise, but different reasons. The pluralism will create the same problem here. That you get you get three groups, and you get two groups that can join their interest, can get their combined joint interest at the expense of another group. Then I'll help you get that if you help me get that, and their love of this. And then since they have no care for that, they don't care for that. They only care for their interest, their thing he's saying here. They will join with the other group in order to eliminate the third group, right? Or harm the second group. However, the formation of simple and even more qualified majorities of the pluralist party state, these types of compromises are typical and institutional, so to speak. For the small and mid-sized parties, the practice of such combination is quite simply a matter of survival. So therefore, the small parties is therefore they get together, they cooperate in order to survive, and therefore they cooperate. Small parties will become useful to help larger parties get what they want. And this is why the Israeli situation is so horrible in that sense, right? As J. Poppins emphatically points out, these parties have an interest in advocating the possibility of constitutional change through statute because in this way they participate in the constitutional amendment majority. But for the fundamental question of interest here, the deviation from the principle of simple majority becomes a special problem. First, because threshold requirements for will formation introduced on substantive grounds must remain in the substantive relation to matters meriting protection. Under the currently valid regulation, however, that is just not the case. In other words, the regulation now is that you have to have super grounds for anything that deals with that. Among the deviations from democratic principle, precisely this disconnect between the reason for making the process of will formulation more difficult, which has a definite object, and the meaning of rendering the process more difficult, which does not have an object, is the most contradictory. If one does not trust the democratic majority, then depending on changing circumstances, perhaps much, though also little, though also maybe little, is gain is in other words, perhaps much, although maybe little, is gained when a few percentage more votes are required. So maybe something might be gained, something might not be gained. We don't know. Little may be gained, some more may be gained, or little may be gained. But what right could these additional votes restore the lost trust? Right, trust the majority. Right? Why, if we don't trust the 51, why should we trust the 2/3 vote? When the objective reason, for objective reasons, certain interests and groups should be protected from the majority, then one must take them out of the process of democratic will formation through the use of special institutions, which are no longer democratic. In other words, we have to use undemocratic means to protect these groups. In other words, one must exempt these interests from and privilege them in the democratic process. But it is not fully consistent to take these interests out of the functionalism and mathematical statistical methods through purely quantitative threshold requirements, and at the same time leave them in. So therefore, okay, in other words, if you're going to protect, if you're doing this thing to protect them, then you're not doing it right. You need to remove them from the process. You need to remove them from the process and give them cesspool status. Yes, this is undemocratic, but you cannot, doing it the way you're doing it, of just giving this quantitative increasement of things, right? In other words, one must exempt these interests from and privilege them in the democratic process. But in the and that's how they did in the Lords, right? The Lords were removed from the democratic process of being able to elect members of. They were not in the Commons. They could only block. They could block. They couldn't initiate that. Right? That's the House of Lords in that sense. So therefore, this is it was yet this is undemocratic, but it still protects their rights, right? Um, but it is not fully consistent to take these interests out of the functionalism of the mathematical statistics through a purely quantitative threshold measurements, and at the same time leave them in. So you're leaving them in the system, right? You make them, you say they have to get a higher thing, but you leave them in the system. In this way, one abandons the underlying democratic principle of the simple majority, which is basically a presupposed homogeneity without going over to some new principle. As noted, such a remedy can still be seen at most a practical technical emergency, a measure of a still unclarified intermediate stage. Right, this was the intermediate stage of development. It is not a question here of whether substantive legal guarantees or constitution like that of the Weimar Constitution, second principle part, are reasonable justified. Undoubtedly, they are, right? They are justified. Nevertheless, they constitute a structural contradiction with the value neutrality of the first principle part, organizing the parliamentary legislative state. And they not only limit the parliamentary legislative state, they also destroy it. First, because such each guarantee and entrenchment means above all security from the simple, ordinary, and normal lawgiver, more specifically the parliamentary majority. What had been the foundation of parliamentary legislative state, the unconditional trust of the ordinary legislature and its current majority, is undermined through constitutional channels, so to speak. Moreover, the scope of these substantive legal guarantees of the second principal part is extraordinarily wide and indefinite. Okay, so therefore, another problem is moreover the scope of these substantive legal guarantees of the second principle are extraordinarily wide and indefinite. With the help of the positivization and actualization of the indefinite concepts, principles, and guidelines contained in the second part, the range of their applicability can be extended indefinitely. So, in other words, given that the positivization, actualization of these things, the indefinite concepts, or the principles and guidelines contained in the second part, their range of their applicability is indefinite. But in the connection of interest here, it is especially noteworthy that substantive legal guarantees of this type create confusion in the functionalism of legislative state, which had been retained despite everything, for which law is the present will of the transient majority. So therefore, it creates confusion. These rights that can be extended like this, then this is, but the statute is law. Okay, there's a confusion here. He says, right. The substantive constitutional guarantee should guard directly against the transitory nature of ordinary legislature, securing a particular matter of securing the primary matter from an empty majoritarian functionalism that surrenders up all substantive value to the current majority, while on the contrary, parliamentary democracy's legislative process should be open to every concern, every opinion, and any aspirational goal. Now, because of the requirement of the higher majority, a new type of momentary transitory apparatus, a transitory apparently enters. The higher law, which is constitutional law, is then simply the current will of a transitory two-thirds majority. Whoa! But this new and higher type of transitory contradicts the first and lower type because it is not considered a form of value neutrality without substance, and hence it is not conceived of in functional terms. So therefore, this is not, in other words, this new type. So Yeah, we got interrupted for a second. We have a new fan here, um, so let's go to this class right here. This higher law, right? But this new higher type of transitory contradicts the first and lower type because it is not considered a form of value neutrality without substance, and hence it is not conceived of in functional terms. So therefore, this is the second, the second point. These things are not they're higher, and they don't share. They're not neutral. They're not viewed and not merely formal, right? This new higher type of the transitory contradicts the first type. He says, right? Its point of departure is that they are practically substantive values singled out by the Constitution itself. Indeed, even sacred institutions of entitlement, such as marriage in Article 19 and the exercise of religion under Article 35, which should stand under the protection of the Constitution itself, while its unconditional value neutrality and functionalist form of the momentary and the parliamentary legislative state should also be serviceable for the elimination of just these sacred objects. In other words, this parliamentary legislation should be serviceable for the elimination of just these sacred objects. On the one hand, obviously, this value emphasis, this system of meanings, Rob M. Schmitt, or whatever one wishes to call the non-functional formulations of the Weimar's constitutional second principal part, conceived of as substantive and essential, is an irreducible opposition to the unconditional neutral functionalism of the organizational first part. According to the dominant interpretation of Article 76, on the other hand, that the Constitution's first part is even indifferent to itself and its own legal system of legality. One cannot put marriage, religion, and private property solemnly under the protection of a constitution, and in the same constitution offer legal means for their elimination. Right? So, therefore, in other words, cannot put under the protection of the constitution, and in one of the same constitution offers legal means for their elimination. One cannot simultaneously reject emphatically godless cultural radicalism and then give it full vent legally by offering it an equal chance. Right? In other words, you can't. In other words, groups who want to destroy those rights in the second part have an equal chance to get into the parliament. Right? So therefore, in other words, this people are going to destroy these principles. Right? The ones who are going to destroy marriage and destroy the property. These are going to destroy these principles. So one not can simultaneously reject emphatically godless cultural radicalism and then give it full vent by offering them an equal chance. It is an inadequate, indeed immoral excuse when one declares that the elimination of marriage or the churches is legally quite possible, but it would then would it be hopeless not to come to a simple two-thirds majority, which would abolish marriage or establish an atheistic or secular state. When the legality of such positivity is recognized, it is self-evident for the dominant functionalism of the concept of law and of the constitutional law. Then all the declarations of the second part of the Constitution are actually hollow, sacred relics, right? In terms of this other thing, in terms of the dominant functionalism concept of law and the constitutional law of the constitutional law, all these things are just sacred relics. Legal theory and legal practice of such constitution faces a simple choice. Give up either the value neutrality of the organizational portion, which is logically consistent in legal, moral, and political terms, or the the substance of meaning of the second part of the Constitution. For the Constitution is a unity, and the more immediate as well as the more remote effects of its axioms are inescapable, even for the entire rudimentary administrative and judicial routine. There is no middle road between principled value neutrality of the functional system of legality and the principal value emphasis of the subjective constitutional guarantees. The functionalism of the weighted majority would be at least a reasonable compromise. In regards to the question of neutrality or non-neutrality, whoever intends to remain neutral has already decided in favor of neutrality. Value assertion, and value neutrality are mutually exclusive. Compared to a seriously intended value assertion and affirmation, conscientious value neutrality means the denial of values. The degree to which the fundamental unconstitutional value neutrality of the now functional system of legality is self-evident for the received view, which considered itself the prevailing opinion, is at best seen in Auschwitz's commentary on the Weimar Constitution, with special emphasis on this leading contemporary of a recognized master terms a new theory and a new type of theory, the opinion held by many current public law scholars that there must be some boundaries to constitutional amendments according to Article 76. But these ever more numerous new theorists, H. Tepero, Karl Bingfinger, E. Jacobi, O. Kello-Rutter, H. Gerber, U. Bruchler, Thomas, L. Jelinek, and K. Wallenstein, and others, differ significantly among themselves in regard to reasoning as well as definition issues. They argue things that should be, but they disagree in reasoning and definition issues, right? The first and most important difference may consist in the fact that few of these authors recognize substantially defined interests or issues as sacrosanct. In other words, these recognize that few of these authors recognize substantially defined interests or issues sacrosanct. Others, by contrast, and above all, are Thomas, and certainly almost W. Jelinek, consider as inviolable only individual internal presuppositions that are conceptually or existentially necessary for the otherwise value-neutral system, such as, for example, a maxim of the objective determined concept of law, of an equal chance of obtaining political power, of free discussion, of election, and of voter rights. Especially R. Thomas, who seeks to discount Karl Bringerwer's and my interpretation of Article 76 as fantasy law. Jacques and Thomas says himself that decisions suppressing freedom of conscience or trampling underfoot any of the other principles of freedom and justice considered sacred in the entire current cultural world, sacred with the exception of fascism and Bolshevism, would be unconstitutional despite the majority's sufficient for a constitutional amendment. So therefore, even that if they had the Constitution, there would be anything that would destroy that would be unconstitutional, even there is. In this regard, the bourgeois legal system itself, with its concept of laws and freedom, is at least still sacred. The liberal value neutrality is viewed as a value, while fascism and Bolshevism are simply termed the political enemy. With Auschwitz, however, the value neutrality of the still only functional system of legality is taken to the extreme of absolute necessity itself towards itself and others, and offers the legal means for the elimination of legality per se. Hence, value neutrality here is pushed to the point of system suicide. Anything is legal without presuppositions or condition that is passed by way of simple statutes or those amending the Constitution. More specifically, that means everything without regards to content and political significance, as Auschwitz himself says. Then this form of value neutrality is the dominant and traditional theory. There is no unconstitutional goals. Any goal, however revolutionary or reactionary, disruptive, hostile to the state or to Germany, or even godless, is permitted and may not be robbed of the chance to be obtained by illegal means. Any limitation of or restraint on this opportunity would be unconstitutional. I would like to stress, in regard to many consultants' reports and court judgments about the legality of the National Socialist Organization, about the civil service laws and the labor law evaluation of the membership in such organizations, about the peacefulness of their gatherings, etc., that for National Socialists, Communists, the godless, whatever, the decisive answer to such questions should be taken from this fundamental interpretation of the system of legality, and especially of Article 76. More specifically, they should be given in terms of objective legal scholarship, and may in no way be taken from individual isolated constitutional articles. For example, Article 118 of the freedom of opinion, or Article 130, political attitudes of civil servants, or indeed of individual provisions of the occasional statute or emergency decrees. In my treatise, the Junta de Vergasen, Defender of the Constitution, 931, this view has already been elaborated on in the discussion of the words neutrality and its very meanings. And he's quoting himself, right? He says, the dominant interpretation of Article 76 deprives the Weimar Constitution of its political substance and foundation, making it a neutral amendment procedure that is indifferent towards every content. More importantly, this amendment procedure is even neutral towards the current existing state form. Under the circumstances, justice requires that all parties be given the unconstitutional equal chance to unconditional equal chance to produce the majorities that are necessary with the help of valid procedure for changing the Constitution to achieve their desired goals: Soviet Republic, National Socialist Reich, the economic democracy state of labor unions, corporate state organized by professions, monarchy in traditional form, some type of aristocracy, and bring about another constitution. Every privileging of the existing state form, or indeed of current governmental parties, whether it is through subsidiaries for propaganda, discrimination in the use of radio broadcasters, official papers, application of film censorship, disadvantage of party political activities, or party membership for officials, in the sense that current party government only permits membership of its own parties or those parties that are not too far from the governmental parties politically, prohibitions of meetings directed at extreme parties, the differentiation of legal and revolutionary parties according to their programs. All of these are crude and egg-ranging constitutional violations in the sense of the reigning interpretation of Article 76. When this interpretation is thought through consistently in its conclusion. In the dominant traditional theory, no parties, aspirations, organizations, and associations can be illegal because of their goals or their content of their goals. To this extent, Hirschenschau is right in comparison with Kohlreuter, who wants to base illegality on revolutionary goal. From the standpoint of value neutrality, a functional system of legality of the Constitution's first part, logic is fully on Herzl's side. When the current majority party or party coalition intends to declare that opposition parties and its organizations illegal as such, it can only do so by misusing its legal powers. With the help of a attribution procedure, which is very interesting in terms of legal history. Punishable actions of individual members of an organization are ascribed to the organization as such. Then, on the basis of collective responsibility, one party, association, organization is simply considered illegal, which once again, especially in terms of criminal law, civil law, and labor law, has a reciprocal effect on every individual member of the organization. Indeed, such an effect of activities of individual officers and state citizens, right? Each suspension of party opponents belong to the above noted political premium on the legal provision of power, right? In other words, it belongs to the legal premium on the legal position of power. But it is one of the partly avoidable, partly unavoidable causes of the collapse of the entire legal system itself. In other words, this issue leads to the collapse. Avoidable causes of the collapse of this system. The Weimar Constitution is literally divided between the value neutrality of the first principal part and the excessive values committed in the second. The difficulty becomes yet greater and irresolvable because the second principal part, substantive goals, are set out next in the generally positive and effective value entrenchments, which are not yet positive and valid, but which nevertheless should be capable of being rendered positive and efficacious through legislation, administration, and practical and legal practice. As elsewhere in this Constitution, two elements stand uneasily along one another. Only latter will it be clear who succeeds in taking full advantage of legal possibilities, but especially in exploiting the political premium from the legal possession of power to use the Weimar Constitution as an instrument and means to their party goals. So therefore, this is the idea that they're using, once you get the political powers, I mean, you can use the Constitution to advance their party goals. When the Weimar Constitution gave up the functionalism of the present and transitory simple majority to such a degree, it was certainly conceivable psychologically that a deeply ingrained formal functional legal theory and practice was able to see the Weimar Constitution's second principal part not as a second differentially constituted constitution. In other words, a formality of the thing. But with a certain inevitability, this legal theory and practice took flight into a new level of this functionalism, held on to the now substantive-less functionalism of the legislative state, also in regard to the content-rich guarantees of the substantive system of meaning of the Constitution's second part, and simply attempted to save the entire image of the omnipotence of the lawmaker, now all the more decisively with the notion of the omnipotent of the constitutional amending legislature. So in other words, the Constitution is omnipotent. Considered more closely, however, it is evident that logically and practically, it is completely impossible to carry over the functionalism of the simple majority to one of these qualified majorities. The threshold requirements, more specifically, direct themselves precisely against the transient and normative quality of the simple majority. In regard to the constitutional law guarantees that are under consideration here, it is a matter of protecting substantively determined interests and claims to their benefit, rejecting functionalism, and its value neutrality, not of introducing a new type of functionalism of two-thirds majority. In other words, it's replacing those functions in the structure, not receiving just functional. Even for reasons of practical necessity, the possibility of interference and interest guaranteed and declared inviolable must be kept open. It is not meant as if the lawmaking amending the Constitution is an analogous manner should now function normally for the inviolable interest as the legality established legislature. That is, the simple parliamentary majority. Violating interests that the Constitution itself declared inviolable can never be normal. Constitutionally guaranteed cannot be normal constitutionally guaranteed competence. Also, the parliamentary legislature state Also, in the parliamentary legislative state, one may certainly not speak of the temporary two-thirds majority as one speaks of the current majority. A current simple majority must always be present if this system of legality is to function at all, whereas a two-thirds majority is thought to be available only as an exception, because otherwise no increase in difficulty lies in the qualification of the majority, the qualification of the majority. There can indeed be a parliamentary legislative state in a type that works with a simple parliamentary majority, but not a constitutional legislative state as a type that works with a two-thirds majority. So therefore, you need two-thirds majority. This is not going to work. This is not a parliamentary legislative state. You can't. There can be one, but there cannot be but there cannot be a constitutional legislative state in a two-thirds one. Even an abstract mathematical examination shows that the parliamentary legislative state system of legality only becomes entangled in contradictions with the introduction of such substantive constitutional guarantees and abandons the functional perspective of momentary presence. According to Article 76, the two-thirds majority is sufficient for amending the Constitution, and present at any particular moment can pass substantive legal norms with the authority of constitutional law, and through it limit the areas of authority of ordinary legislature, that is, the simple majority. But by abandoning the principle of simple majority in this way and requiring stronger majorities, the functional principle of the transitory is also simultaneously destroyed. Under these conditions, specifically, the present two-thirds majority can create lasting effects and obligations, even for itself and beyond the momentary presence, that are unreasonable and unjust under any conceivable perspective. So therefore, in other words, in an undemocratic or anti-democratic way, a two-thirds majority can place limitations on the will of the people itself, even when it no longer has control over the majority. If the total number of representatives is 600 and 400 votes can decide this substantive legislative prescription with the effect of a constitutional law, such an issuing of alcohol prohibition, for instance, if the number of the prohibitedness fall back to 301, hence still under the simple majority. So the former two-thirds majority, according to its present voices, could no longer have issued the alcohol prohibition even as a simple law. The alcohol prohibition nevertheless remains a lasting, revocable premium on an earlier, one-time achieved two-thirds majority when the opposing side over 300 votes determines its elimination. Under these circumstances, it is no more use of these 300 votes than they do not have a simple majority, as long as they do not themselves achieve control of 400 votes, while it does the prohibitors no harm that they no longer have a simple majority. The number of prohibition may sink as low as 201, with 399 opposing votes posed against them. The contest of will of the 200 now compels the will of the 399, only because under the violation of the functional perspective of the present and momentary, a new type of premium on the earlier, once qualified majority is being introduced. A premium that, considered democratically, is senseless and even immoral. The introduction of norms that are more difficult to change contains a direct invitation to exploit such premiums and to extend inappropriately the duration of current majorities holding power. Such efforts come noticeably into view when the substantive constitution guarantees secures constitutional a faculty of legal position created through the simple statute, or indeed through a mere administrative act. In other words, this old provision than through either a simple statute or that. Although the appointment of official, for example, the party in power via simple majority can occupy the personnel of the state administration and judicial apparatus. This extension of power can be secured even against a subsequent majority due to the constitutional guarantee of the acquired rights of civil servants under Article 129. As above shown, such temporary extensions of legal power beyond the duration of its fleeting presence is also possible with simple momentary majorities for the immediate period of indecisive majorities. But here it is a matter of the present, temporary majority being bound by no longer present prior majority, because the constitutional solidification has the consequence of discrediting and destroying the majority principle. The introduction of qualified majority contradicts the principle of the parliamentary legislative state, and finally permits itself to be taken so far that its last, though formally fully consistent, consequence is the legal elimination of the principle of legality itself. So the consequent is its legal elimination of the principle of legality. The two-thirds majority amending the Constitution could use that the moment of its majority to decide that with constitutional force that certain interests and certain persons are in the future protected against 100% of all the votes, and that specific norms are not subject to change through any type of majority or even unanimity. For an abstract formal thought it is quite legal, quite in order, and however placed beyond the possibility of legal revision. The fact that, with the guarantees, the second principal part of the Weimar Constitution contains the counter-constitution in the first instance stems from the contradiction between the value commitments and value neutrality of the constitutional system. At the same time, however, the principal contradiction is a direct constructive organizational one, namely that of a jurisdictional state vis-a-vis the parliamentary legislative state. So therefore, this second one is really a jurisdictional state via personal parliamentary legislative state. A constitution that, to a great extent, places priority on substantive constitutional law over simple statutes, not only changes the principle of the current will of the majority and the legislative principle that rests on it. Such a constitution changes the organizational structure of such a legislative state from the ground up. In a legislative state, as a state form dominated by general, predominant, lasting norms, laws and legal applications, lawmaking, and officials responsible for legal principle must be distinguished from one another and remain separate. And this separation of powers determine the organizational construction of the state. Laws in a legislative state must typically be a simple statute, generally and a generally normal process of state life. Fortunately, under proper circumstances, one cannot say the same of a constitutional amendment. As noted, passing a constitutional law that is higher type of statute is extraordinary procedure. Consequently, in such a legislative state, the constitutional lawgiver cannot simply step into the function of the ordinary legislature, where the latter provision is shaken through the assertion of the higher norm. The distinction of higher law and simple statute are unavoidable organizational effects, regardless of whether those effects are anticipated and regulated in Constitution itself, or whether they occur in more or less unintended consequences in legal and administrative practice. Where in a larger radius a particular substantive law complex stands opposite the substantive law set by a simple legislature as configurations of the lower and higher form, respectively, And this distinction rests precisely on the mistrust towards the simple, that is, the ordinary legislature, and configuration of higher norms as need of concrete organizational institutions in order to be protected from the ordinary legislature, right? So these new higher things that need an institution, organization. For no norms, neither a higher nor lower one, interprets and applies and protects or guides itself. Nothing that is normally valid enforces itself. And if one does not intend to trade in metaphors and allegories, there is also no hierarchy of norms, but rather only a hierarchy of concrete persons and organs. Organizationally, the legislative state is characterized by the fact that it places the norm on one side and the norm execution distinct from the norm on the other. So the norm is on one side and the execution is on the other side. Right? This is the legislative state, or the organizational legislative state. In this way, the distinctive system of legality should arise, of one which can say with some justification that there is neither persons nor officials, nor even lawmaking bodies command, but only the norms that which these bodies issue are valid. So therefore the bodies, in other words, there's the words, in this way, the distinctive system of legality should arise, of which no one can say with some jurisdiction that in neither persons nor officials, nor even lawmaking bodies commands, but only the norm of these bodies, that these bodies' issues are valid. So these are not valid, but these norms are valid, right? It is conceivable under the entirely it is conceivable under entire situation-specific presupposition, but it is no longer conceivable, at least not as a legislative state. When a qualitative difference is incorporated into a singly definitive concept of norm, therefore, when substantive reasons, there is a definite differentiation of higher and lower legality. It is not, if it is not to succumb to a meaningless and abstract functionalism, the legislative state must indeed retain certain qualities of its concept of law, but these qualities must not be of a substantive law variety. So they can't be of a substance, they'll be formal. To this degree, it is neutral in terms of content. However, not only is the lower norm as norm degraded through the previously mentioned substantively grounded differential internal grounded differentiation internal to substantive legal norm, the juxtaposition of law on the one side and legal application on the other, the essential organizational construction of the parliamentary legislative state that rests on this separation, are all put into question. That's this hierarchy of this. Moreover, those responsible for legal application face cases involving the application of a higher as well as a lower norms. And it is possible that in the internal procedures of office applying the law, the higher norm will be validated by those at the lower position in the overall hierarchy. So therefore, this higher, whether no specific institution forms to protect the higher against the lower law, and consequently the organizational boundaries of parliamentary legislative state are openly ruptured, then it becomes a matter for the organs applying the law in the judiciary, government, and administration to define in the course of their official duties the limitations of ordinary law to which they are subordinated by reference to the higher law. So they have to define clearly, each one of these have to define what is it becomes a matter of the organs who apply a law in the judiciary, governmental, and administration to define in the course of their official duties the limitations of what is law as compared to this. One readily sees that everything here depends on the type and scope, the number and structure, the definitiveness or indeterminacy, of the previously noted higher norms. So are they permanent? In other words, the higher norms must be what? The question of whether they are everything will determine everything on the number and structure, the definitiveness and determinacy of these norms. So therefore, the types of scope, number and structure, and the definitiveness and determinacy of these higher. With larger numbers and with more general content of these higher norms, the subordinate legislation's realm of validity is not only qualitatively limited, hemmed in, but also to the same degree the power of the executive and judicial officials responsible for legal application grows in regard to the ordinary legislature. Therefore, the bureaucracy and the legislature get more power. The judicial and this gets more power over the lawmaking body, and the legislature in this regard. Of the executive and judicial offices responsible for legal applications grow in regard to the ordinary legislature. How then the executive and judicial conduct themselves in relation to one another, whether the one takes use of the other or subordinates it, or whether a contradiction also occurs here, is another question in of itself. In regard to the ordinary legislature, perhaps it then subjects itself to the higher legality realized to legal administration in the judiciary, the governmental or administration, semicolon. That is, the legislature rescinds its statute, passes another, and in this way recognizes the higher organs as the new guardians of the Constitution. But perhaps the ordinary legislature finds support in one part of the apparatus of legal application, for example, the government against the judiciary, or the judiciary against the government, and insists on its standpoint. In this first case, the state transforms itself from a legislative state into a partly jurisdictional state, or partly governmental state, or administrative state, in other words, depending on which office makes use of the higher type of legality. So therefore, in other words, which one is the ruling thing? Is it the legislative state and they all will point to the higher legality is justifying there? No. So, in other case, these develop a series of freestanding independent power configurations that adhere firmly to their position in an unorderly proximity to one another, so long as pressing need for or the violent force of a unifying decision does not bring this type of mixed state form to an end. In other words, this is the mixed state where this has this higher norm. He's talking about this is the mixed state. The mixed state is when there's a higher norm and that these things are like this, and that this is the mixed state until what? In other words, as long as this power figures will adhere firmly to their position in unorthodox proximity to one another, so long as the pressing need for violent force or unification does not bring this state to an end, right? In other words, a new situation, a situation of crisis happens. In any case, through the fissure of the system of legality into higher and lower forms, although apparently only a qualitative arithmetic difference of the voting majorities is present, the legislative state is shaken up into its organization foundations. Divisions, restraints, counterbalances, internal and legislative processes, such as the bicameral system and other complications, do not eliminate the legislative state, so long as one still insists on the qualitative unified value of statutes that come into being in this way. On the contrary, the distinction between substantive statutes of higher and lower forms forces the lawgiver out of the position of central central setter of norms, through which the state first becomes a legislative state. This distinction slices like a knife into the comprehensive organizational construction of legislative state and reshapes it through the fact that in the course of applying and enforcing the higher legality, agencies and organizations unavoidably arise that are superior to the ordinary legislature. all the concepts particular to the legislative state, such as the rule of law, omnipotence, priority of statute, legislature reservation, have always have the simple legislature in mind. So these concepts. These concepts also account on a constitution with no substantive law regulation of significant scope, but rather the ones that contains a fundamental rights section that guarantees the bourgeois sphere of civil and political freedoms in general, and such stands opposition to an organizational part regulating the process of state will opposed to an organizational part regulating the process of will formation, process of state will formation. So how the will is formed, the state is first. The priority of the statute is precedent. The priority of the statute is the precedence of the statute itself over the application, while the statutory reservation is potentially broad legislative restrictions on a general liberty right. Right, restriction on general. The priority of the constitutional amending statute, by contrast, is a precedent of one type of statute over another. It is a priority that divides the sphere of the statute into higher, superior type of legality and lower, inferior one. Sorry, hiccups. The reservation of the state amendment process in the constitutional the reservation of state amending the reservation of the state amending the Constitution favors special interests and protected objects with particular content. By lending statutes constitutional status, the statutory reservation solidifies substantive law and the acquired rights of particular groups. Substantive constitutional law, therefore, deviates from all the principles of parliamentary legislative state. So, substantive constitutional law deviates from all principles of the parliamentary legislative states, just as it does from the democratic constitution. It is qualitatively different from the simple, properly concluded statutes. And it is also evident here that it is not possible to carry over concepts and formulas from the 19th century legislative state, developed for simple statutes, and then and apply them to the statute in the form of a constitutional amendment without changing the state fundamentally. So in other words, you just can't. The old processes can't be done. In other words, the old formulas of doing things, the old constitutional formulas, this won't work under this new principle because it's a fiction. Because the constitutional provisions are now higher and than the mere provision of statute, and therefore these must conform to these, or this restraint, or it makes no sense, right? So therefore the old formula, concepts and forms of the 19th century legislation makes no sense without changing the state fundamentally at the new state. In terms of the state and constitutional theory, the state of state and constitutional theory, term Stadtler, right? One comes to a conclusion that next to the well-known distinction between states with and those without written constitutions, another distinction comes into play, which is not less definitive. Specifically between states with constitutions limited to organizational procedure regulations and general liberty rights on the one hand, and those with constitutions containing extensive entrenchments and guarantees in the forms of substantive law on the other. In truth, these are states with two different constitutions or constitutional components, which contradict one another in principle, both structurally and organizationally. Actually, it should be self-evident that the type of state form is determined by its variety. It should be self-evident that the type of state form is determined by its variety of basic and fundamental rights, and that the general liberty rights, both civil and procedural, of the bourgeois Reichstag, the bourgeois right state, right, with its legislative reservations, clauses permitting restrictions on right in forms of simple, properly situated statutes, constitute another type of, in other words, there's its legislative reform. It is self-evident that the type of state form determines these fundamental rights, which general liberties, both civil and political, of the bourgeois right state. It should be self-evident that this state form that is determined by the variety of basic fundamental rights, and that of the bourgeois right state, with its legislative reservations pertaining clause restrictions on the rights of in the formal simple property past statutes, constitute another type of state form. Okay. Which also stands under the reservation that certain types of statutes can amend the Constitution. General liberty rights define the social structure of the individualistic order, and the maintenance and preservation of which the organizational regulation of the state would serve. In this way, they are generally fundamental principles, and as one said of the principles of 1789, the foundations of the entire public order, la basis du right, public right, right? These fundamental principles contain a super legality which rises them above every regulation of an organizational and constitutional type of facilitating and preservation, as well as over any individual regulation of a substantive law variety. So these basic rights, these common rights, this seems to be kind of like an assumption, right? So that it is the foundation of law, public law, foundation of public law in a sense, right? These fundamental principles contain a super legal dignity, which raises them above every regulation of organization and constitutional type, facilitating their preservation as well as over any individual regulation of substantive law variety. As an outstanding French public law specialist, Maurice Rouge, 1923, put it, these principles have a superlegate constitution. In other words, they're constitutionally, they're superlegality. In other words, they have, what is this? They trump the, superlegality, constitutional superlegality, that's it. Constitutional superlegality, that raises them not only above routine simple statutes, but also over the laws of the written constitution. In other words, they're even above the even laws of the constitution, and rules out their elimination through statutes amending the constitution. But even they eliminate even statute, in other words, they rules out their elimination through statutes amending the Constitution. They even define the Constitution. I agree with Lulu that every Constitution recognizes such fundamental principles, but these principles belong to what Carl Billfinger determines the constitutional system, which is in principle unalterable. We are also in agreement that it is not the intent of constitutional provisions concerning revision of the Constitution to open a process of eliminating of the elimination of the system of order that should be constituted through the Constitution. When a Constitution visions the possibility of constitutional revision, the Constitution does not intend to provide, for example, a legal method of elimination of its own legality. Still less the legal means of destruction of its legitimacy. So in other words, he's not saying this Constitution cannot say no amendment to the Constitution can then say this Constitution should be ignored like that. Strong its own legitimacy and its own legality as well. Legitimate means to destroy its legitimacy. But even apart from already discussed question of the boundaries of constitutional amendments, one should not fail to recognize the difference between general bourgeois liberty rights and specific guarantees of substantive law nature. In other words, substantial law nature. These two things are different. The second principal part of the Weimar Constitution contains an assortment of different types of higher legality, the complete heterogeneity of which has until now hardly been recognized and even well less thought through. It also contains part of a counter-constitution. As a result, there are two different principles and systems here. Contemporary German public law must come to terms with the contradiction, and yet it wants to remain on the neutral middle road of value-free functionalism. Value-free functionalism. There was German constitutional law. There's a contradiction in the law. He's saying that we have to do this. This is not just that the principles here are not merely just basic principles that we can find in the bourgeois state right, but rather this is more complicated because this is these things are in contradiction. Principles of both these parts are in contradiction, and that German law does, but the German law simply won't do that because it wants to say value neutral, right? Middle road value free functionalism. Consequently, the remarkable results occurs that the fundamental principles of general freedom and property. In other words, consequently, the remarkable result occurs that the fundamental principles of general freedom and property, both pertaining to the Reichstag, have only 51% lower legality, whereas the rights of religious societies and officials, and in several cases, even the rights of unions, by contrast, have the higher 67% legality. So property rights in this thing, oh no, 51% can overturn that. But the other things, moreover, there is further consequence for the entire state structure that the institution and power elements of government, administrative or jurisdiction state, directed against the legislative state becomes unavoidable. And here we end it. Ooh, this has been a long one. So he ends it with this weird thing, pointing at that he says that moreover, there is the further so therefore you have this weird situation where certain things that should be that can be overturned by a simple majority, but other things that are provisions in the second part of certain rights that are becoming required of 51, 60, the 67% majority legality, right? So, oh my God! So therefore, this is a very funny thing. So therefore, not only is there a contradiction between the two parts that doesn't do, there's also the problem of that some of these things here are some things are basic in the Constitution that should be treated as though it should be are being allowed to be removed by simple majorities, but others that are specifically presented there are not done that, right? So moreover, there is the further consequence for the entire state structure that the institutions and power elements of the government and jurisdictional state against the legislative state becomes unavoidable. These things become fighting each other. These different things, and because of the principles of because of those provisions of higher constitutionalism, become means that the governmental state, the administrative state, and the jurisdictional state against the legislative state become unavoidable. And this is the situation that he says we're in. And this ends our examination of chapter 3. We'll see. Okay, right now, if you like it. Please like it, share it with a friend, share it on social media. If you have not subscribed, and subscribe. If you know someone who liked this, ask them to subscribe. Encourage others to join and subscribe because we need to grow the channel a little more. If you didn't like what I did here, if you didn't like it, or you have issues, say what the issues are, and maybe we can all learn. Maybe you didn't like the content. Maybe you disagree with Schmitt or something. Another thing, if you want to follow me on social media, the links are below. The links are below. Other things you can do if you want to help me do what I do by contributing financially. Of course, send me money. Send me the money. Yes, please, please, please. Send some money, please. Please, please. Yes, please, please. Okay. Okay, I'm not going to TikTok myself. Like, these TikTok people and these celebs. Like, okay, okay, yeah, okay. Send me money, or you can become if you want to do it by a small way. But the easy way to do it is become a Patreon member or subscribe star. I of course, but you say, well, you're doing it free. You're not doing anything special for us. You're not giving us any content. Well, I'm giving you content. I try to give 5 days a week, and trying. This is hard. Some of it's very long. I should make smaller content, right? But if I do that, this would take forever, right? Um, um, so another way you can help is by buying one of my books. The links are below. Um, uh, 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 that would help. In two of the books, I don't get the money directly. I haven't gotten money from my university. I get little money every year. I get some money from the LSU book. Some. I make more with the Lulu book. Okay, the Lulu book I'll make more from it if you buy it, especially from Lulu. Um, the university, Washington University, but so far I haven't got any money from them yet. So I'm kind of like depressed. Well, that's it. We'll take care. I hope you're all well and fine and dandy. Again, these are posted Tuesday, Thursdays with currently our Schmitt. We'll look at chapter 4 next time. Then what we do is on Monday, Wednesdays, we look at, still we're looking at Montesquieu here. We'll be continuing Montesquieu. Then what we do is on Fridays, we do something special, either a messing around video or a live stream. Okay, well, that's it. What I do. Take care and have a good day. Take care. Bye bye. See you next time we meet. Bye bye.